So I think I understand what's going on with the Deboraugh Rodgers case. For those of you who aren't aware, she was caught allegedly driving under the influence and allegedly with in possession of a firearm that she shouldn't have had, or something along those lines. Not entirely sure. She was on an Indian reservation when she was arrested. The Indian reservation is the Cherokee reservation, and there are two tribes on the Cherokee reservation. One is the United Keetoowah Band of Cherokee Indians, and the other one is the Cherokee Nation. Now, her argument is she was arrested by the Cherokee Nation. She is charged by the Cherokee Nation. She's been hauled into court by the Cherokee Nation. She thinks that she should be tried by the United Keetoowah Band. And so she's filed this motion to dismiss. Now, today, the questions were raised because she actually filed her appeal, and that paperwork is now available to the appellate and final court in the Cherokee Nation judiciary, which is the Supreme Court of the Cherokee Nation. And her appeal is poorly worded, but it's probably sufficient for them to figure out that she's challenging jurisdiction. That's ultimately what she's asking for. She went a long way around doing it, but she's basically challenging the jurisdiction of the Cherokee Nation to hear her criminal action, to have a criminal action against her. She's saying the Cherokee Nation can't charge me, they can't try me, they can't convict me because I'm a Keetoowah, and the United Keetoowah Band of Cherokee Indians are the ones who have jurisdiction over the crime and over me. Okay? Does everybody understand that? If not, well, I'm sorry. So she states, this is from her motion to dismiss. I'm going to ignore her appeal for now. Well, I'm going to ignore her appeal for this particular video and say that she's going to lose it. She is a duly enrolled member, in quotes, in the United Keetoowah Band of Cherokee Indians in Oklahoma, UKB, and a citizen, in quotes, of the Cherokee Nation of Oklahoma, CNO. So she's saying that she is a member of the Keetoowah Band and a citizen of the Cherokee Nation. Keep that in your head. Another person who was charged with the crime, Kimberly Gilliland, was charged with, I'm going to say embezzlement. I don't exactly remember. I think it was embezzlement. Anyway, she challenged the jurisdiction of the Cherokee Nation to charge her with the crime and to try her because she did not think that the Cherokee Nation had extended its territorial jurisdiction to make and enforce laws to the extent of the reservation. And so it was her argument that the Cherokee Nation had not formally extended its jurisdiction to fee lands within its former reservation. Fee lands are lands owned not necessarily by the tribe, but land owns in fee, I own my house in fee. You know, it's in the state of California, but I own it in fee, so it's my house. And her assertion is essentially that California has not formally extended its jurisdiction into her house. Now, admittedly, it wasn't her house; it was the business she was working at. But you get the idea. She argued that the Constitution and statutes of the tribe, as well as its past conduct, indicate the tribe's jurisdiction is limited to lands held in trust for the tribe, restricted allotments, and dependent Indian communities. So the court goes and looks at it and says Article 2 of the Cherokee Constitution of 1999. Now, this is a 2018 case. This was filed August 13th of 2018. It was signed August 13th of 2018. This is a 2018 case. Article 2 of the Cherokee Constitution of 1999 defines the territorial jurisdiction of the tribe. Territorial jurisdiction. The boundaries of the Cherokee Nation territory shall be those described by the patents of 1938 and 1948, diminished only by the Treaty of July 19, 1866, and the Act of March 3rd, 1893. So that's the territorial jurisdiction. It then goes on to talk about the district court's jurisdiction. It has jurisdiction over criminal matters. Reading these two constitutional provisions together, there does not appear to be any acknowledgement of a self-imposed limitation on jurisdiction. Title 20, Sections 24 and 25 likewise do not purport to limit the jurisdiction allowed under the Cherokee Constitution. Clearly, each case must be approached on its facts, and Cherokee jurisdiction is not unlimited. Notwithstanding, the district court does have jurisdiction, and this is the important thing. The district court does have jurisdiction over crimes of this nature. I mean, there's the Major Crimes Act. Certain crimes like murder, for example, the federal courts have jurisdiction over those, and they may have exclusive jurisdiction over it. I'm not entirely sure. I don't think the case law is particularly well settled, but federal laws, the Major Crimes Act, it's like 18 U.S.C. 1152 or something like that, or 18 U.S.C. 1153, somewhere in there. So unless the federal government has limited the jurisdiction, the district court has jurisdiction over crimes which violate Cherokee law committed by Cherokee citizens within the historical boundaries of the tribe. Now, they reference Murphy versus Royal, which is a fairly complicated case. I'm not going to get into it. Murphy versus Royal. Murphy versus Royal does a lot of discussion of it's a massive case. It does a lot of discussion about reservations and whether or not Congress has diminished it, etc. I mean, it goes way beyond the scope of what we need to talk about. But the important one is Deboraugh versus Riena, and this is a United States Supreme Court case, 494 U.S. 676. Now, Deboraugh versus Riena deals with an Indian who is a member of a tribe, let's call it Tribe A, who is on Tribe B's land. So he's an Indian, and he's on tribal lands, but it's not his tribe's land. And he kills a 14-year-old boy for whatever reason, I don't know, don't really care. And the tribe whose land he was on, Tribe B, wanted to charge him with a crime. Now, he killed someone, so he's subject to the Major Crimes Act, but they wanted to charge him for unlawful discharge of a firearm, which, I mean, it had a paltry like $500 fine and 6 months in jail maximum. I mean, he's facing felony murder charges in federal court, but he certainly didn't want to have to face anything from this Indian tribe when he got out of federal court. So he challenged the jurisdiction of the tribe, Tribe B, because he's not a member of Tribe B. He's a member of Tribe A. And the Supreme Court, this is a 1990 decision, and it's still good law, decided that Indian tribes have jurisdiction over their members. Crimes committed by their members or against their members, I believe. In this case, the boy was a member of a different tribe. So the boy he killed was a member of Tribe C. So the interests of Tribe B basically doesn't really exist in this particular fact pattern. The person who was killed is a member of a different tribe, and the person who did the killing is a member of a different tribe, right? But in our case, Deboraugh is a citizen of the Cherokee Nation of Oklahoma. And if you look at this Supreme Court decision from the Cherokee Nation Supreme Court, It is their law and their understanding, and it's also backed up by a Supreme Court case, if that has any merit for you, that the district court, the Cherokee Nation District Court, has jurisdiction over crimes like driving under the influence or unlawful carrying of a firearm, whatever, within the which violate Cherokee law committed by Cherokee citizens within the historical boundaries of the tribe. I don't think any of those things are contested. If true, the charges for a violation of a Cherokee law, whether she did it or not, that's hasn't been decided, hasn't been adjudicated yet. But the charges for a violation of Cherokee law, she is, by her own admittance, a Cherokee citizen. She's a citizen of the Cherokee Nation, and there's no dispute that she was pulled over on the reservation. So 3 for 3 and done. Now, I don't know why I have this up here. Because I was trying to look up their Bill of Rights and things like that. So here's where it gets spicy. Now, why isn't the Keetoowah Band getting involved in this? Because remember, she says she's a member of the Keetoowah Band. According to this website, which is the Southern Plains Tribal Health Board, they say that enrollees in the United Keetoowah Band of Cherokee Indians in Oklahoma cannot carry dual citizenship in both the UKB and the Cherokee Nation of Oklahoma. Now, I tried to verify this with the United Keetoowah Band of Cherokee Indians in Oklahoma, and this is on their membership page. While not illegal, our enrollment ordinance does not permit dual enrollment in terms of providing services to members. This is in part to prevent double dipping of federal funding given to our tribe and that of others. Most commonly, dual enrolled members are affiliated with the other two federally recognized Cherokee tribes, the Eastern Band of Cherokee Indians and the Cherokee Nation of Oklahoma. So they don't permit it. They don't permit it. Now, they say they don't permit it in terms of providing services to members. I don't know. Their enrollment ordinance I can't find online. They say they don't currently have a published code, and I can't find it. But it sounds like Keetoowah Band is going to consider her to be a member of the Cherokee Nation, not a member of the Keetoowah Band. So I think that's why they're not doing anything to step in. If Deboraugh was not a citizen of the Cherokee Nation, then under Deboraugh v. Rodgers, and without this Cherokee Nation Supreme Court decision would also back it up, the Cherokee Nation wouldn't have an interest in her. They wouldn't be able to they wouldn't have jurisdiction over her because she's not a member of their tribe, and there's no victim that's a member of their tribe. So I think she screwed herself right there. Now, I could be wrong. The United Keetoowah Band, their ordinance might say that, we accept dual citizenship except to give services, and so whatever. I haven't read it. I don't know. I'm going by what their enrollment page says and what this Southern Plains Tribal Health Board says. So I could be wrong. The Cherokee Nation of Oklahoma, on the other hand, they have no problems with dual citizenship. So if you're on their reservation and you want services, because that's typically where the citizenship would come into play, is when you're seeking services. They don't care if you're on their reservation, and as long as you're Cherokee Nation of Oklahoma citizen, they'll give you the services. So anyway, I hope you found that helpful and informative. I wish Deboraugh the best of luck. So yeah, so she's still being held apparently. So I think also I thought that she was assigned a attorney just in general for her case and for the criminal action against her and for the contempt. It kind of looks like she only has the attorney for the contempt, so she may still be acting pro se, pro per, for the actual criminal charges. So that'll be interesting to see which way that shakes out. Without having like more detailed minutes, it's really hard to determine what's going on there. But like I said, I really do think that her appeal is sunk. Thanks for watching and have a great day.